Well, that was the defense attorney who was passionately opening for his client. It's called an opening statement, a good opening statement. He's referring to the government as the government, showing that it's the government against his poor police officer. And this is just a case that the police officer was doing what he was trained to do. So I'd like to discuss real quickly, before we get back into it, with our guest, Girley Girley, attorney extraordinaire, a former police officer, a man of God who preaches the gospel. Jerry, what were your immediate thoughts about this opening?
Well, of course, he's trying to place the victim in a bad light with the jury. I mean, because if the jury obviously feels that Laquan McDonald is a bad guy, then that increases the likelihood if they're going to have to go one way or the other, they're going to go in the direction of the police officer. So simply trying to create some doubt or suggest that there's going to be reasonable doubt. And that's how I construed the actually his opening statement.
Okay, real quickly, because we're running out of time. When he said, and the prosecutor objected, he was giving a jury charge, right? When he objected, and you have to answer me yes or no, did he get caught by not using the word necessary force, telling that jury that it has to be necessary first?
I think so, because that word necessary is critical. I mean, what a reasonable police officer would have deemed to be necessary is very important. So necessary is critical.
Okay, so Jerry, there's so much to talk about. We are going to talk about it. First, we're going to go to break and then come back to this trial. But this is a major case. Stay tuned. Law and Crime. We'll be here at the end. Okay, so we are at the sidebar right now. And as you know, you do not hear the sidebar of the attorneys. They're probably discussing what the person on the stand, who's the great aunt, can be asked, what she can answer, because obviously there is an objection. This happens all the times in trials, right, Girley Girley?
Correct. And there's doing this outside of the hearing of the jury because there are evidentiary issues being raised, and you don't want the jury to be exposed to things that ultimately are not admissible. But
going back to what we were discussing before, this is a case, and somebody had asked on the Law and Crime chat room, which I ask all of you viewers to go to, about has the defense attorney ever referred to a state prosecutor as the government. I know I did in the Phil Spector case #1, because you want it to be this little person, no matter who you are, against this big machine, the government of the United States. How about you, Jerry? Oops, they're coming back, so let's see. We'll get more into this when they go to another sidebar or take a break. They're not coming back, I understand. They are still discussing. They're returning to their counsel table. They're probably prepping. The court reporter who is taking everything that happens in the courtroom is resetting up her machine. There's a lot of technical stuff that goes on, Girley Girley, in a trial, right?
Absolutely. I mean, and the critical part about the court report is that she's making the record in the event that there's going to be an appeal. And there's likely going to be an appeal whichever way the jury decides.
Okay, so it's I have to cut you off because we're going right back in right now. This is the trial of police officer Jason Van Dyke. It's the first trial, from what I understand, of a police officer in Chicago, maybe in the very near future, in the near past, for actually killing somebody who's 17 years old. Now, it doesn't happen all that long. It doesn't happen all that often that police officers get charged. Girley Girley, who is a former police officer, who is a trial attorney extraordinaire in civil rights. I have a question to you. Why are we dirtying up the victim? If this victim were killed by 16 shots answering his front door, would we be talking about all the stuff that the defense attorney is trying to get into and will get into, I understand? Because if I'm a defense attorney, I know that's where I may be going. Why are we dirtying up the victim?
Well, the short answer is that you're trying to make that individual a less sympathetic figure to the jury. Bottom line. Now, when I'm getting ready to go to trial, I tell my clients, if we're contemplating trial as opposed to some other kind of resolution, in a trial, there's going to be a good guy and a bad guy. If you're the bad guy, we don't need to go to trial. So obviously, in this instance, they're trying to make the victim the bad guy.
Well, the victim, as we know, is 17 years old. The victim, as we know, only had a knife. The victim, as we know, was not close to the officer when he shot. So we're going to see how all this plays into whether or not there was a defense in the mind of the officer. Okay, we're following the trial of police officer Jason Van Dyke for the killing of Laquan McDonald. The dispatcher, whose name is Tabitha Theory, is on the stand. So what we're going to see is the dispatcher on the stand in the courtroom, okay? Now what she is doing is she is giving the basis so that we can hear how police get to a scene. They don't just jump in. They don't just automatically parachute in. They have to know something. And it's very important what Laquan McDonald knew, according to the defense. Very important. Because he has to have a reasonable belief that his life is endangered before he shoots anybody, whether it be a 17-year-old. Now, we're following in the courtroom. The jury is coming out. So as soon as we get to that, we're going to go straight back in. I'm going to stop talking because we have to listen closely because this is a very important case. Now, Jerry, as the jury is going to be coming in, does the view of what the officer hears from the dispatcher, can that color his mind as to what he's going into on a scene?
Oh, absolutely. I mean, if you're told that there is a robbery in progress, an armed robbery in progress, that's going to obviously give you an adrenaline dump as opposed to a shoplifting in progress. So it matters very much what dispatch tells the police officer.
Now, Jerry, you worked for the Atlanta Police Department and Technical Services for 7.5 years.
That's right.
You have a badge, but you know what? I have to cut you off right back into court. Let's not miss a minute. All right, so the video or the 911 call, it's not a video, the 911 call that's presently being played before the jury, I don't know if you can hear all of it, but it's going to set the stage as to what the police officer who shot Laquan McDonald knew. What did Jason Van Dyke knew? Because when you're going into, as you heard, a charge of whether or not a force is reasonable, it's also in the mind of the police officer what he believes is reasonable. So Jerry Girley, you worked next to police officers for 7.5 years. You kind of almost was a police officer in the sense of you supported them technically. You're an attorney, a civil rights attorney. Now, what do you do if you're the prosecutor to overcome the feeling that the jury may have had from the defense attorney that indeed the homicide was justified? Well,
to me, there are two critical facts that I would point to and I would hammer home consistently. Number one, when they did their initial report, they alleged that Laquan McDonald launched at them, and that is what created that imminent sense that they were in danger. The video, once released, showed that that was absolutely a falsehood, so that goes to their credibility, and I would hammer that home from start to finish. That would be in my opening statement. That would be the basis for my cross-examination of the officers, and that certainly would be in my closing statement.
And what's the second thing that you'd hammer on?
The second thing is that, look, there were other officers there at the scene. They perceived similar things. Why didn't they shoot? Why was he the only one who took a shot, and not only that, took as many shots as he did? So,
but aren't officers trained to empty their gun? I mean, it's not just one shot when they're trained. They just keep on the trigger and they empty. Aren't they taught that, to empty their gun?
Not necessarily. I think that they're trained to neutralize the threat. And so, no, not necessarily. It's not a certain amount of shots that they're required to take or trained to take. Just if, in fact, you do believe that there is an imminent threat to yourself or your fellow officers or the public, then you can act up to and including using
we are going to have to then listen to the testimony that's going to continue to occur in that courtroom in Chicago for the death of Laquan McDonald. A police officer's on trial. Stay with us. So let me fill you in right now. It's Tabitha Theory. She's the Chicago police dispatcher. She had to authenticate the radio, the 911 call from the radios of the officers, and then she calls back out and tells them. And what she's telling you, you couldn't really hear it, is that she's telling the officers that there was somebody who was breaking into trucks and stealing radios, and that the officers then started following the suspect. And she also called for a taser unit, which is, as we know, a less lethal use of force. It's not a gun. It can't kill you, hopefully, although there's an argument that sometimes it does. And so she has now told the officers and they're responding to that. that. So that's what's in their head at this point. Okay, so that's the setup right now. We're waiting to see whether or not there's going to be any further examination of her or whether or not we are going to change witnesses. I know it was very hard to hear the 911. I'll go to Law&Crime, obviously. We're keeping up with it on the website, the chat room. The chatters are all into it. So if you can't hear something, go to the chat room, go to our website. I'm going to bring on attorney extraordinaire, Girley. Now, Jerry, okay, are you there? You're listening,
I'm here,
right?
absolutely.
Okay, so one of the things you and I spoke about while they were breaking was the use of the drone. The defense attorney said they're going to recreate what was in Officer Van Dyke's mind by using a drone to talk about what he saw. Now, it seems to me if I'm up in the air in a drone or the drone's flying over me, I'm really not seeing, right, what the officer saw.
Absolutely, and what we also talked about, is that there is video that establishes what was going on objectively. What the defense is trying to do is create an alternative reality that is totally inconsistent with what the objective evidence shows.
Okay, so let's see if they start through cross-examination. The next witness is on the stand. We're going right into the courtroom. So the person who was just on the stand was also a Chicago police officer. His name was Jeffrey Malik. Now, what he did is he got the videos from the different cars, and he had to take them out, put them on a DVD, and basically authenticate them. When you have a trial like this, there's a lot of boring testimony, but the jury, when it hears the evidence, we have to make sure that it's hearing the right evidence, seeing the right videos, hearing the right 911 calls. So that was just what was going on. We're actually going to a new witness right now who's about to identify himself.